We do have to wrap things up. We're going to do concluding statements now, and as agreed before the debate, we're going to go in reverse order. So, Sam, if you want to.
We're going to go reverse
Oh,
order.
I'm sorry. Yes. So Richard's okay.
First off, once again, thank everybody in the audience for coming. Thank everybody on the panel for being here. I appreciate y'all. So we've heard the practical and historical and legal arguments, and I want to shift gears now and talk about the groups themselves, and why they have such an obligation to fight against this movement. Let me remind you that Wolf-PAC is a volunteer organization with 5 full-time staff members on their payroll out of the thousands of people that are working all across the country in all 50 states right now. So, Upton Sinclair once said that his quote, "It is difficult to get a man to understand something when his salary depends upon his not understanding it." Now, let me clarify before I cross the line into insult. Now, I've met Seth. He's a great guy. He is. He's given me lobbying tips at the Capitol before, and I believe him to be an honest actor. When he says that he's genuinely afraid of the convention, I believe him. And Eli, great guy as well. I mean, we've done a forum together on money and politics. When he says he supports public funding of elections, I believe him when he says that. He's an honest actor. And the Ohio team, who we have members of here today, we reached out to Common Cause for this because they assured me that the leader of the Common Cause group in Ohio is an honest actor. We wanted to hear her opinion as well, and she unfortunately couldn't be here today. But all of them, like the majority of us, have bosses and take orders from the top down. So Common Cause has been working on campaign finance for nearly 50 years and have won some victories along the line. But campaign issues have grown arguably incredibly worse since they've started on this. And I don't feel that they're the experts on this anymore, and they're definitely not the experts on the Article 5 convention. They once stated, quote, that because of much of the money that comes from secret donors, voters lack clear knowledge of who's actually funding a particular candidate or initiative and what his or her agenda is. Voters don't know what the funders expect in return for the money spent. So, in other words, any group that doesn't disclose their donors shouldn't be trusted, like Sam mentioned earlier. Well, Common Cause does not disclose their donors, and they haven't since 2013. So, who gave them $450,000 last year? I don't know. But I do know that I'm not going to take Common Cause at their word when they say that they have an honest opinion. And I urge you to judge the arguments on their merit alone. Now, the ACLU was formed over 100 years ago, and they've been heroic in defense of our civil liberties and our constitutional rights. And I feel that we're all the better for having groups like the ACLU working on the issues they are today. Now, but once again, they're an organization that has bosses, and they're a top-down organization. So the ACLU has a board of directors to set their policy, and their policy on free speech and campaign finance regulation, straight from their own legal director, David Cole, is, quote, to have a very tightly defined, compelling interest to justify the regulation of speech. Equalization is much harder and murkier to define, and so at this point the board is not comfortable with this justification, end quote. Now, even David Cole was on the record as saying that he's against this opinion. But being an ACLU member, he's forced to defend it. Yeah, that is why the ACLU wrote a brief in support of Citizens United. And so is the ACLU against Article 5 because they principally believe it's dangerous? Or is the ACLU board more interested in keeping their donors happy so they can continue to do the other great work that they do? The ACLU does not disclose their donors. And for an organization like the ACLU, unlike Common Cause, it's very understandable. But it also does mean that they sacrifice some of their credibility on issues likely to upset their donors. So please listen to the arguments, not merely the deservedly venerable name of the ACLU. Now, the Center on Budget and Policy Priorities does great work on budgeting and policies that affect real communities. And once again, like I said, Seth's a great guy, man. I love learning him at the Capitol. So we know that the Center opposes the Balanced Budget Amendment. And but we also know that the Center for Budget and Policy they're not experts on constitutional law, and they aren't the experts on the Article 5 Convention. And they've been using a lot of the same talking points as Common Cause, which Sam pointed out, are based in conspiracy theory and misrepresentation, not upon the actual research. So I fear that the Center has fallen to the same propaganda that has been so readily distributed by Common Cause since the 80s, and has attacked this mechanism to attack the BBA call instead of attacking the actual merits of the issue itself. Now, all of Wolf-PAC's funding is from regular people like Sam, myself, and our members that are in the audience today. Our biggest donor wouldn't make the top category on Common Cause's 2013 donors list, one of the last ones we're actually able to get.
Last one.
Contrary to some fringe opinions, we are not funded by George Soros, I can assure you. You can see any of our donations over $200 on the FEC website, and all of our, as they're all disclosed. And once again, we have 5 national paid members. But the rest of us are lawyers, pizza delivery guys, insurance agents. We're regular people. And we've become active citizens because, this is such an important issue. So, we've studied the peer-reviewed research, and I would remind you that 100% of peer-reviewed research agrees that the Article 5 Convention can be limited to one specific issue. And if you would like to look at some of that peer-reviewed research, wolf-pac.com/resources. Feel free to read it for yourself. Don't just take my word for it. So, other groups would ask you to imagine what would happen if we had a convention. I'm infinitely more afraid of what will happen to us and to our country if we continue to cower in fear to inaction instead of leading with courage to demand our constitutional rights, or demand, as Madison said, a government dependent upon the people alone. Thank you.
Seth, yes.
Yeah, you're right, yeah. I will, there's a Facebook event page for what we're doing here today, and I will post this paper from my colleague Michael Leachman and David Super at the Center for Budget and Policy Priorities, outlining why states likely really could not control a constitutional convention on a balanced budget amendment or other issues. It will include endnotes and citations, and you are more than welcome, and I really encourage you to kind of dive in to deeper on a lot of the things I was talking about here today, because I think they do a really good job outlining the potential dangers and the just very vague nature of this mechanism that is put in the Constitution, but not much else is said about it at the constitutional level, right? We don't know how the ground rules would be established. It is very vague, I think, at the federal level, whether or not the federal courts could intervene in the case that a convention starts to get away or starts taking up issues they're not supposed to be taking up. Just want to say thank you, ultimately. I do a lot of different types. It's the first time I've had the opportunity to come talk about Article 5, and I usually talk about food stamps or Medicaid or the incredibly exciting subject of taxes. And, usually that's what I get to do. And usually it's in rooms with not this many people. So just by virtue of the fact that there are this many people willing to come and engage on policy and serious issues, especially as it relates to our current political system, and how it is not really working for all of us, but maybe just for some of us, gives me a lot of hope for the future. A couple of endnotes. Thank you to our participants today. It's great to see Eli and Richard. I'm more than happy to keep those lobbying tips rolling for you.
Thank you.
And thank you for
I need them.
Thank you for coming down from Massachusetts to be with us, to talk about this. From my perspective, I don't know how much more I could say it, but I don't want to beat a dead horse. I'm just telling you, there is a lot I think that could go wrong with an Article 5 convention. And when things go wrong at this particular level, a lot of your most precious rights, a lot of the things that make America very unique in the world, as far as what our democracy is, and what we enjoy as being just by having 2 feet on the ground in this country, could stand to be lost. And I think there are better ways of doing things. The Constitution offers a different way of doing things. And I think that, at the end of the day, caution is needed. Thank you all so very much. We appreciate it.
Thank you. I have to say, Seth, I'm disappointed that you're choosing to put out your sources after the debate instead of actually discussing them here.
I thought I did. I told everybody.
Yeah, this is the first time you're mentioning that paper by Super and Leachman. I will take a look at it and respond to it in that Facebook group. I'm not familiar with Mr. Leachman. I am familiar with David Super. His area of expertise is not Article 5. His area of expertise is budgetary issues. And I've noticed that's a trend in this debate. Usually when you see these issues discussed, we hear quotes by supposed experts or people who've said this or that about it. We often hear quotes by Lawrence Tribe or Antonin Scalia. And I came here today expecting that, which is why I brought with me a video to play of Lawrence Tribe saying he's being taken out of context, and of Antonin Scalia giving a glowing review of why we need to use the Article 5 convention method because of the runaway Congress. And when you go through all of the points used by our opposition, all of the supposed debate ends up getting categorized in one of a few areas. It's either people where this is not actually their area of expertise. If you look at the Constitutional Treatise by Rotunda, is one of the most notable constitutional scholars of the last century. It's 6 volumes long. Each one's about 1,000 pages. Most constitutional scholars are an expert on like that much of it and a tiny sliver. When you actually look at what he said about the Article 5 Convention, it was glowing. And he wrote a separate paper aside from his treatise on it in 1996, which gave a glowing review of why this is a process that's safe to be used. When you look at something that was said by somebody who did not study this area, it came out very different. And it's good to know how those kinds of talking points, or sometimes you see sources cited where they didn't even say what they're accredited for saying, like Scalia, for example. And it's good to know where some of these false talking points have come from. There was a concerted effort in response to the Balanced Budget Amendment starting back in 1979. I actually have a memo here, which I did not find handy. Yes, over here. A memo from the group that was trying to respond on this issue on the Balanced Budget Amendment, outlining their proposal and what they were going to do in response. And they came up with 6 proposals. One of them was hold a hearing with the aim of demonstrating the risks of calling a convention. They held that hearing in November of that year. Another was try to coordinate a behind-the-scenes campaign to quell the state legislatures from urging Congress to call a convention. They did that within a couple of weeks of this memo from January 16th of 1979. Number 6 on their agenda was screen, which they certainly did as well. What they ultimately did was they took anybody they could find, like Lawrence Tribe, who has some questions about the way the Article 5 convention process might work, the same questions that James Madison had, but ultimately his real problems with the Balanced Budget Amendment. And when he testified in 1979, the bulk of his testimony was about the Balanced Budget Amendment as a policy. This group, which included the ACLU, it ended up being called the Citizens to Protect the Constitution. The ACLU joined as a member, as did Common Cause, as did the John Birch Society, as did the Eagle Forum. They ultimately went with taking just those minor procedural issues and saying, no, let's be afraid, let's run away. They looked at work by Charles Black, who, before he studied this, and he was a notable civil rights professor, not somebody who actually studied Article 5. The one thing he said about Article 5 before it came to the political issues was in favor of it in 1964. In the 1970s, in response to the political issues, he was opposed. In the 1980s, reflecting on his career, he didn't stand by anything he had said in the 1970s. And we see that sort of thing over and over again. There's a legal doctrine, ipsa dixit. It's Latin for stuff he said. Ultimately, it's the doctrine that says that opinion, even expert opinion, should not be considered and should not be given weight if it goes against the body of scholarly research. Now, Eli has said, and I'm sure he will repeat in a minute, that there is a real debate on this issue, and that what they're doing is not what the tobacco companies did, and is not what the opponents of climate change are doing. Well, when you've got the entire body, I've read a lot of scholarly research on this issue, and I've read a lot of op-eds on this issue. When all of the op-eds say one thing and all of the scholarly research says another, it sounds an awful lot like what the tobacco companies did. Thank you.
All right, well, again, I want to echo everyone else by thanking everyone here for being here tonight, and thanking, again, my friends here and Mr. Fieldman in particular for making this trip out here.
Thank you.
This is a topic we could talk about for a week or a month. Again, certainly there are hundreds of pages of scholarly journal articles about it, so we tried to compress a lot of information in a single night. Again, I'm going to start by conceding the point I conceded in the beginning of this, which is that money in politics is a problem. It has been a problem for as long as a country, whether it was the wealthy landowners who got to set all the policies, whether it was the problem of the slave owners who essentially pushed their financial interests so hard that they pushed our country to a civil war, whether it was the people during the Gilded Age, or the people pushing back against the progressive era. Money in politics has been a problem. The first campaign finance law was passed in 1907, with Teddy Roosevelt being the one to raise this issue. So this is not a new era. This is a new phenomenon. This is not something specific to this particular era. And money in politics will be a problem so long as we value free speech and free political speech. Because whether it's corporations, whether it's individuals, people with money will try to influence elections, will try to influence the body politic towards their ends. And it is virtually impossible to find a way to stymie that without infringing on that freedom of speech. And this is why, even though it's been controversial, I do believe it is appropriate that we protect free speech over trying to limit these contributions, that we rely on that promise of a marketplace of ideas where we expect people to be engaged citizens. That's the responsibility of being an American citizen, is that you pay attention, that you vote. We've gotten away from that, and we expect laws to fix everything. We expect constitutional amendments to fix everything. It's not going to fix things. We need people to go back to being citizens of this country. Now, we talked a little bit about how during that Gilded Era, senators were appointed by state legislatures, and that created a huge problem with bribery. Well, guess who would probably be appointing delegates to any sort of Article 5 convention? State legislatures. If we're concerned about money being a corrupting influence, that's certainly an area where there'd be corrupting influence. Now, one other thing I want to point out here, Wolf-PAC on their own website, they said tonight, say that 100% of all peer-reviewed articles support their premise that conventions can be limited. In the area of the law, there's only one peer review that really matters, and that's the peer review of the courts. And ultimately, everything comes down to one court making one decision. That's the Supreme Court. No case is so certain that we should leave it up to one decision, to 9 justices, to decide whether or not we're going to open the entire U.S. Constitution, all those rights, all the protections that we take for granted, to being interpreted any way we want, whether it's through a full runaway convention where the Supreme Court says, hey, look, no, you can't do this, or whether it's through something more narrow where we say we're going to allow this particular call to creep out a little bit. We should be incredibly cautious. We should be so wary of allowing that one court, that one decision to interpret it. We should watch out for. Now, one more thing I want to point out here as far as Wolf-PAC goes, on their sources, on their websites, they've got a number of articles from the Department of Justice. There was one thing that stood out in one of those articles to me when I was reading through them. They point out that in the time period between 1788 and 1893, there were only 10 calls for an Article 5 Convention of the States. Only 10 in that over 100-year period when the founders were alive. All 10 of those calls were for general conventions. So while we can talk about what the historical precedent was, there was certainly potentially an understanding that this would be something more open. Now, again, you go on, you read it further, they say that was probably due to the politics at the time. I want to acknowledge that. But this is the issue. When we're talking about the history and we're expecting history to dictate what a court's going to decide today, we're leaving it open to a lot of chance. This isn't disingenuous policy. This is really looking at how a court might decide something. So I think we have to be very careful doing this. Again, that's the point I want to make. I also want to say again, we have to protect speech, and we know that we can change culture. We know that that's the way we're actually going to get this done.
Thank you. Okay, well, this has been a fantastic debate. I know there are many more issues that need to be discussed concerning this, and I thank you all for coming. I want to thank each of the individuals who came here, especially people who came from far away. So we're going to thank them individually. So can we thank Sam Fieldman first, please?
Thank you so much for holding this forum and for inviting us down here. It means so much.
Yeah, thank you very much. Richard Saffle.
Thank you guys for caring enough about this to come out. I'm glad this isn't just important to me. I'm glad to see this reflected in the community.
Eli Baumwell.
Thank you, everyone. This was fantastic.
And Seth Disefano. And we have a round of applause for the organizers as well. Thank you, everyone, for coming. Have a good night.